And now for the arbitration. Like the Argentine tango, an international arbitration follows basic forms and proceeds according to basic steps. The first step in the dance is to formally institute or begin the arbitration, a process in the arbitration system of the International Center for Settlement of Investment Disputes, governed by Article 36 of the ICSID Convention and by a separate set of ICSID rules known as institution rules. The convention and the rules require a disputant seeking ICSID arbitration to make a written request for arbitration that at a minimum contains information on three elements. First, the identity of the parties to the dispute. Second, the issues in dispute. And third, their consent to ICSID arbitration. In the Aguas case, the four foreign investors, Suez, Vivendi, Akbar, and AWG Limited, initiated the process by sending a written request for arbitration against the Argentine Republic to ICSID Secretary General on April 17, 2003. On the same date, the same foreign investors who had also invested in the privatizations of the water and sewage systems of the Santa Fe and Cordoba provinces filed two other separate requests for arbitration against Argentina for injuries sustained by those investments because of government actions or failures to act. They also requested that the same arbitration tribunal hear these two other cases along with the Aguas Argentina case. We'll examine in this video only the anatomy of the case of Aguas Argentinas. As we saw in part one of this course, any arbitration requires the consent of the disputants to be valid. The ICSID institution rules require information on that consent in addition to basic information about the nature of the dispute. The four investors relied on Argentina's consent to arbitration in the individual bilateral investment treaties that each of their home countries had signed with Argentina. Thus, Suez and Vivendi invoked Argentina's consent to arbitration in Argentina's 1991 BIT with France. Akbar relied on Argentina's consent to ICSID arbitration in its 1991 treaty with Spain, and AWG relied on Argentina's 1990 BIT with the United Kingdom. Following a common pattern in each of those BITs, Argentina promised investments and investors from France, Spain, and the United Kingdom various protections. It also agreed that if a dispute arose on whether a government had lived up to those promises, an investor from one contracting state would be entitled under various conditions to invoke international arbitration against Argentina to settle the matter. In Aguas Argentina case, however, there was a wrinkle. Whereas the French and Spain BITs made an unconditional promise of ICSID arbitration in the event of an investor-state conflict, the UK BIT stated that in case of a dispute, Argentina and the investor concerned may agree to refer to their dispute either to ICSID arbitration or to arbitration under the arbitration rules of the United Nations Commission on International Trade Law, INCITRAL. If they did not reach an agreement after 3 months, they had to submit their dispute to arbitration under UNCITRAL rules. In the Aguas case, Argentina refused to submit AWG's claim to ICSID jurisdiction, but it did allow AWG's claim to be administered by ICSID under UNCITRAL rules. The case would therefore proceed on that basis. That is, the same tribunal would hear the claims of all foreign investors, but apply two sets of arbitration rules to the case. ICSID rules would govern the claims of Vivendi, Suez, and Akbar, but UNCITRAL rules would govern AWG's claim. While the ICSID Convention and rules refers to the parties, that is, the investors as claimants and the state as the respondent, taking certain actions in the case, in reality, it is the parties' lawyers who drive the arbitration process. Virtually all investors engage lawyers, often from major international law firms, to press their cases. And governments being sued may also hire foreign law firms to defend themselves. In the Aguas Argentina case, the investors engaged the international firm of Freshfields, Brookhouse, and Derringer, LLP, while Argentina chose to rely on the lawyers from its Attorney General's department, the Procurador del Tesoro de la Nación. At arbitration hearings, each side would be represented by a legal team of 10 or more persons, consisting of lawyers, paralegals, experts, and administrative assistants. It was the legal teams that prepared all the pleadings and documents in the case, including the request for arbitration, and they also participated in the oral hearings. After the ICSID Secretary General received the investors' request for arbitration, a copy was forwarded to the government of Argentina. The ICSID Convention requires the ICSID Secretary General to register the request unless, quote, it is manifestly outside of ICSID jurisdiction. On July 17, 2003, the Acting Secretary General registered the request, gave it a formal name and number, informed the parties of its registration, and asked them to constitute a tribunal as soon as possible. That action began the second step in Aguas Argentina, that is, constituting the tribunal.